Welcome to UXL, where you can learn new skills anytime and anywhere. Visit uxl.com to explore our full course selection. This lesson is part of a larger course. Check the video description below for a link to the full course where you can enroll. If you enjoy our content, please like and subscribe. For your convenience, the course cover displayed on your screen provides the complete course title and lesson title. Let's proceed with the lesson. Lesson: Regional variations in data subject rights. Regional variations in data subject rights present a complex landscape for privacy professionals aiming to ensure compliance while addressing diverse legal standards and cultural expectations. Understanding these variations is crucial for certified information privacy managers who manage data protection programs across different jurisdictions. This lesson explores the nuances of data subject rights across various regions, emphasizing actionable insights and practical frameworks to navigate these challenges effectively. Data subject rights, as defined by regulations like the General Data Protection Regulation in the European Union, grant individuals control over their personal data. These rights include access, rectification, erasure, restriction of processing, data portability, and the right to object. However, the interpretation and implementation of these rights can differ significantly across jurisdictions. For instance, the GDPR is often regarded as a gold standard in data protection, offering robust rights to individuals. In contrast, the United States lacks a comprehensive federal privacy law, resulting in a patchwork of state-level regulations with varying degrees of data subject rights. The California Consumer Privacy Act is one of the most notable, providing rights similar to the GDPR, but with distinctive differences such as the right to opt out of data sales instead of a broader right to object to processing. To effectively manage these variations, privacy professionals can utilize a comparative framework that assesses the specific rights granted by different regulations. This framework involves mapping out the rights provided by each jurisdiction, identifying commonalities and differences, and understanding the enforcement mechanisms in place. For example, while both the GDPR and the CCPA offer the right to access, the response timeframes and the scope of access can vary. The GDPR mandates a 1-month response period, whereas the CCPA requires businesses to respond within 45 days. By employing a comparative framework, privacy managers can develop tailored compliance strategies that address the specific requirements of each jurisdiction while maintaining a consistent approach to data protection. Another practical tool is the implementation of a centralized data subject request management system. Such systems enable organizations to efficiently handle requests from data subjects across multiple jurisdictions, ensuring timely and accurate responses. These systems can automate workflows, track request statuses, and assist in verifying the identity of data subjects. For instance, a global company operating in both the EU and the US can use a centralized system to ensure that access requests are handled within the respective legal timeframes of each region. This not only enhances compliance, but also improves the organization's ability to demonstrate accountability, a key principle of data protection regulations like the GDPR. Case studies illustrate the importance of understanding regional variations in data subject rights. A prominent example is the enforcement action against Google by the French Data Protection Authority for GDPR violations. The CNIL fined Google €50 million for failing to provide transparent and easily accessible information to users about how their data was being processed. This case underscores the necessity for organizations to adapt their privacy notices and consent mechanisms to meet the stringent requirements of the GDPR. Conversely, in the US, the Federal Trade Commission has taken action against companies like Facebook for privacy breaches, focusing on deceptive practices rather than the comprehensive data subject rights found in the GDPR. These cases highlight the need for privacy professionals to tailor their compliance efforts to the specific enforcement priorities and legal standards of each region. Statistics further underscore the diversity in data subject rights enforcement across jurisdictions. According to a report by DLA Piper, EU data protection authorities have imposed over €272 million in fines under the GDPR since its implementation in 2018. In contrast, the U.S. has seen significant penalties primarily through FTC actions, such as the $5 billion fine against Facebook in 2019 for privacy violations. These figures demonstrate the varying levels of regulatory scrutiny and the financial implications of non-compliance in different regions. To enhance proficiency in managing regional variations, privacy managers should engage in continuous education and training. Staying informed about legislative changes, enforcement trends, and emerging best practices is essential for adapting compliance strategies. Resources such as industry conferences, webinars, and publications from reputable privacy organizations can provide valuable insights and updates. Additionally, fostering a culture of privacy within the organization, where employees at all levels understand the importance of data protection and their role in supporting compliance efforts, can further strengthen the organization's ability to navigate regional variations effectively. A practical step-by-step approach to addressing regional variations involves conducting a privacy impact assessment focused on jurisdictional differences. This assessment should identify the specific data subject rights applicable in each region where the organization operates, evaluate the current compliance status, and highlight any gaps or risks. Based on this assessment, privacy managers can develop an action plan that prioritizes areas for improvement, such as updating privacy notices, revising data processing agreements, or enhancing data subject request procedures. By systematically addressing these issues, organizations can achieve a more harmonized approach to data protection that respects regional variations while ensuring compliance. In conclusion, regional variations in data subject rights present both challenges and opportunities for privacy professionals. By leveraging comparative frameworks, centralized management systems, and continuous education, certified information privacy managers can navigate these complexities effectively. Understanding the nuances of different regulations and adapting compliance strategies accordingly not only enhances data protection, but also builds trust with stakeholders and strengthens the organization's reputation. As the global data protection landscape continues to evolve, staying informed and proactive will be key to maintaining compliance and safeguarding individuals' rights across jurisdictions. This concludes the lesson. We trust you found this video informative and engaging. To enroll in the complete course, please use the link provided in the description below. At UXL, we are committed to your learning journey. Each course offers a certificate of completion, online support, and downloadable resource files to enhance your experience. If you found our content valuable, we invite you to like this video and subscribe to our channel. Thank you for joining us, and we look forward to supporting your continued pursuit of knowledge.